In a major ruling today, the Supreme Court said that some employers cannot be forced to cover birth control in their health plans if that violates their religious beliefs. Contraceptive coverage had been mandated for employers under Obamacare. The decision was 5-4, with Chief Justice John Roberts providing the swing vote, and you may recall he was the swing vote in the ruling 2 years ago that upheld most of Obamacare. Jan Crawford has more about today's decision and what it'll mean.
We say no way!
The case was a political firestorm, pitting women's rights against religious freedom. Inside the court, the justices also were deeply divided and sharply at odds in their approach to the case. The majority decision by Justice Samuel Alito emphasized religious rights and marked the first time the court has allowed a for-profit corporation this type of religious exemption. It was a victory for family-owned companies like the Hobby Lobby chain of arts and crafts stores, whose owners David and Barbara Green challenged the law. The court said the health care law clearly imposes a substantial burden on the Greens' religious beliefs because it requires them to offer coverage for specific forms of birth control, like the morning after pill and the IUD, which the Greens believe facilitate abortion. It said there are other ways the government could ensure that every woman has cost-free access to the particular contraceptives, making the impact on women employed by the companies precisely zero. Lori Wyndham is an attorney with the Beckett Fund, which represented the Greens.
What the Supreme Court said is that families do not give up their religious freedom when they open a family business.
But liberal justices, led by Justice Ruth Bader Ginsburg, frame the issue as one of women's rights, saying the court discounts the disadvantages to those who do not share the corporation owner's religious faith. Cecile Richards is president of Planned Parenthood.
The Supreme Court is now saying, actually, that a for-profit company has the same rights as a church, that somehow the particular religious views of a CEO trump the right of the employees of that company to have access to family planning services.
Now, the court insisted that its decision was focused only on those closely held businesses whose owners have sincere religious beliefs, and not the large publicly traded corporations. But Scott, opponents said this decision nonetheless is going to open the door for many other legal challenges.
And the Census Bureau tells us about half of Americans work for those companies. Jan, thanks very much.